Welcome back you all to the lecture series on corporate law. This is Professor Kondaiah Gadda. In the continuation of lecture series, now we will be discussing on the types of the prospectus, otherwise called the types of document. After the incorporation of the company, every company tries to issue the securities and raise the capital by issuing of the document that is called as prospectus. The other name for the prospectus is the offer document. The methods and mechanisms provided in the Companies Act in order to raise the capital, either it may be the debt capital or it may be the equity capital, various mechanisms are provided or different modes are available depending on the nature of the mode, method in which the company adopts. Then their company would be preparing a document which we call as offer document, and it has the various types as described and as explained in the Companies Act 2013. Let us see the types of the documents. And as for the section 2 clause 70 of the Companies Act, the prospectus has been defined is a document which is described, issued as a prospectus and includes. So the first category is, one is called about the red herring prospectus. Second category is about the shell prospectus or any notice, circular, advertisement which is in the nature of a prospectus or an offer document inviting for the public for the subscription of the shares or the securities or for the subscription of the debentures or any of the financial instruments. Let us see what are the various types which are given under the Companies Act. We will see one by one type of the prospectus and to whom it applies. Then the first and foremost type of the prospectus is abridged prospectus. Abridged prospectus means it is a memorandum containing the silent features of the prospectus as specified by the SEBI regulations from time to time. So it is as simple as that. It is very clear. It is a shorter form of the prospectus, and the format and the contents of the prospectus are defined and regulated by the SEBI regulations. In the SEBI regulations, from time to time, it tries to explain. So the first and foremost prospectus, the nomenclature itself explains to us, is abridged prospectus, which has the silent features of the prospectus. Silent features of the prospectus, in one of our previous lectures I have discussed, the silent features includes the contents of the prospectus as given under the section 26 of the Companies Act 2013. So Companies Act 2013 talks about the contents, otherwise called about the silent features of the prospectus. The other prospectus is advertisement of the prospectus. Section 30 of the Companies Act defines about the advertisement of the prospectus. When you look about the section 30, the language or the legal language of the advertisement of prospectus is that where a company or where an advertisement of any prospectus of a company is published in any manner, it shall be necessary to specify contents of memorandum, liability of the members and amount of the share capital, the names and signatories of the memorandum, and the capital structures. So, advertisement of the prospectus is also one of the shorter form which contains some of the features, right? Which contains some of the features and not the all the features of the prospectus. So advertisement is which are given in the form in the prospectus, advertisement which is published in the newspapers, which is published in the permitted or approved newspapers, and the advertisement should contain some of the features. The features are the object clause of the company, the features are the who are the members of the company, and followed by the members who subscribed the capital and how much capital that they have subscribed, and other one is the capital structure of the company. So the second type of the prospectus which we can learn from the provisions of company law is that section 30 of the Companies Act, which defines about the advertisement of the prospectus. Let us move on to other type of the prospectus. Section 31 of the Companies Act is another prominent clause which was introduced in the Companies Act from 1998 onwards, because prior to the 1998 it was not there. It was existing in the 1956 Act from 1998, and later on in 2013 Act we are having this particular prospectus. Shell prospectus is a prospectus which is applicable to the class and classes of companies as defined under the SEBI, right? SEBI decides this is applies to the class and classes of companies, right? Some of you may have a doubt, what are these class and classes of the companies? Because the Companies Act, we try to define two types of the companies. One is private limited, other one is public limited, right? As we all know all very well, right? It is understand principle that private limited company is not provided, is restricted under the Companies Act not to go to the public for raising of the capital. Therefore, we are discussing the shell prospectus which is applicable to the listed public companies and also the companies which comes under the special category, and the class and classes of companies are defined. Class and classes of companies are provided by the SEBI from time to time. That is one of the important concept. Second concept, the shell prospectus is valid for a period of 1 year, right? So try to remember, section 31 of the Companies Act provides the validity of the prospectus. The validity of the shell prospectus is 1 year as compared to the prospectus which was valid for the 90 days, right? Section 26 of the Companies Act talks the validity of the prospectus is not more than 90 days, whereas the shell prospectus is valid for a period of 1 year. Now let us see the meaning which was given under the provision of the section 31. Shell prospectus means a prospectus in respect of which securities or class of securities included therein issued for a subscription of in one or more issues over a certain period without issuing of the further prospectus. It seems more complicated, it seems more legal language. I will read it again. Shell prospectus means a prospectus in respect of which securities or class of securities included therein are issued for subscription in one or more issues over a certain period without the issue of further prospectus. That means the companies, right? The companies are class of companies who prepares a prospectus, keep in a shelf, right? Keep in a shelf. They go on further issue of the capital over a period of time. You don't require to prepare a complete prospectus again and again. Therefore, the advantage of this prospectus is valid for a period of 1 year. And this is also advantage when you look at section 31, the advantage is that this prospectus will commence from the date of opening of the first offer of securities under the prospectus. In respect of the second or subsequent offer of such securities issued during the period of validity of that prospectus, no further prospectus is required. Subclass 2 of the section 31 specifies, right? Section 31 subclass 2 specifies a company filing a shell prospectus shall be required to file an information memorandum containing all material facts relating to the new charges created, changes in the financial positions have occurred between the first offer of the securities and the previous offer of the securities and succeeding offer of the securities. Let us take a small example. If X Limited Company, which is permitted by the SEBI, right? X Limited Company, which is permitted by SEBI, who can prepare the shell prospectus issuing. It has prepared the shell prospectus and made a public issue on October 16, 2022. And it comes a class of companies that is called X Limited Companies Special Class, and also taken approval from the SEBI. Now, if the same company plans to go for the further issue of the share capital 16/2/2023, that means after 5 months, then they can also go with the same prospectus, because from October, November, December, January, February. So you have the 5 months time is given, where the same company which has been classified the SEBI may use the shell prospectus. However, during the 5 months, if any changes happens, that those changes regarding to the financial positions, regarding to the material facts, and any new charges which are being created need to be mentioned the documents or the prospectus which comes in the 2023. In the ordinary prospectus, it becomes not valid within a period of 90 days. Whereas in the case of shell prospectus, according to section 31 of the Companies Act 2013, since the prospectus is valid for a period of 1 year, therefore, even from the October to the next year February, that is February 2023, because in October 2022, if the company issued the prospectus and comes back to the February 2023, they don't require to prepare another full prospectus. The company can only prepare a shell prospectus, and it has to prepare a document called information memorandum. You may also have another doubt. For what companies this shell prospectus is broadly applicable, or what are those companies involved in preparation of the shell prospectus in the broader perspectives? To the best of available literature, to the best of the practice of the corporate law, the shell prospectus is applicable to the companies which are involved in the finance of the business, right? Financing of the company and finance of the businesses, or financing in corporate law, it is applicable to them, and these companies can prepare the shell prospectus. This is very brief regarding to the brief description, brief analysis of the shell prospectus. As and when you require, you can read the importance of the prospectus in the light of the guidelines, in the light of the regulations issued by the SEBI from time to time. So there are two legal regulations, there are two legal documents which regulates the SEBI. The first and foremost is the Companies Act, section 31, and the second one is the SEBI regulations amended from time to time. Now let us move on to the other type of the prospectus, right? Other type of the prospectus is red herring prospectus. It is also has very prominent importance the today's contemporary corporate world, where the corporations are using one of the mechanism of raising of the capital by using the document of the red herring prospectus. Red herring prospectus means, and red herring prospectus has been explained under the explanation of section 32. Red herring prospectus means a prospectus which does not include complete particulars of quantum or the price of the securities included therein. Repeating again, red herring prospectus means a prospectus which does not include complete particulars of the quantum or price of the securities included therein. So it is not containing the complete details of the public issue. It contains only certain features. Now let us see what are those features are there. Section 32 deals a company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of the prospectus. Therefore, step 1 is RHP and step 2 is about the prospectus. In between, we are also having the another document. A company proposing to issue the RHP on the step 1 under subsection 1 you are having here under subsection 1 shall file with the registrar at least 3 days prior to the opening of the subscription list and the offer. A red herring prospectus, that is a RHP, shall carry the same obligation as applicable to the final prospectus, and also the RHP is also called as the prospectus. So initially the company files prior to the opening of the list of subscriptions the RHP, that is called red herring prospectus, and red herring prospectus is as equivalent to the prospectus. So red herring prospectus is one of the very prominently used in the public issues, where the importance and one of the mechanism available to the corporations to raise the capital. So therefore, section 32 class 2 of the Companies Act talks about the company. Then it talks a company proposing to issue the RHP under subsection 1 shall file with the registrar 3 days prior to the opening of the subscription list and as well as to the public offer. So another type of the prospectus which has been a very widely used prospectus is the red herring prospectus. Now on subclass number 4, upon closing of the offer of securities, a prospectus stating the total, a prospectus stating therein the total capital raised, whereby by way of the debt or share capital and the closing price of the securities, any other details as are not included RHP, shall be filed with the registrar and the SEBI after closing of the offer. That means step number 1 is RHP, then open of offer, thereafter the closing of the offer, then the closing of the, you go for the allotment of the securities, and later on you file the final prospectus, the final prospectus before the registrar and before the SEBI, So this is how it goes on the stepwise formula. A red herring prospectus prior 3 days before the opening of the open offer. It has some of the features which does not include the total number of the shares as well as to the price of the shares. Then once you close the public offer and later on you allot the securities, because you have to allot the securities, you close the prospectus. After that, after completion of the total public issue, then you will file the complete prospectus, one before the registrar of the companies, other before the SEBI. So red herring prospectus has another practical importance, where the corporations uses in order to raise the capital. Either it may be the debt capital, it may be the share capital. Kindly remember, red herring prospectus is for both the purposes of red herring on the debt capital, equity share capital. Repeating again, the share capital, debt capital and the share capital. That means a company may raise the capital by virtue of debentures. Debentures means acknowledgement of the debt, and also equity shares. Then they can use the mechanism of red herring prospectus. It is not that only one purpose only you use about the red herring prospectus. Now moving further to the another type of prospectus which is given under the Companies Act. Other mechanisms are the modes. I put it in a simple understanding to all of you. Depending upon the types of the companies, the public company or the private company or any class of companies, as permitted by the SEBI, as permitted by the other stock markets, they use the different devices, they use about the different mechanisms, different documents in order to raise the capital. Because public company may raises the capital through public offers. Private company may raises the capital through the private placement, right? Public company can raise the capital through public offer. And the private company may raises the capital through the private placement. So where you have the raising of the capital by these two mechanisms, the companies may devise by using of the document either through notice or circular or maybe the advertisements or maybe any other documents as which is given under the section 2 clause 70. One addition to this, the other type of the companies are class and classes of companies, right? It may be the class of companies and classes of companies which comes under the public companies. So the class and classes of companies are decided by the SEBI from time to time. So when you see the types of companies are the companies which are using various documents. In a brief, the name of the company is public companies, private companies, class of public companies, classes of public companies. They use the different device and they use the different documents. And what type of prospectus is required to be for what type of company, it is given to the wisdom of the management of company, right? Companies Act is not specifying that what document has to be used so and so company at one point of time. Companies Act only specifies if the company is raising the capital by using of a particular document, by using either circular, by using as an advertisement or by using of the notice, then it has to follow the rules and regulations of ICDR. It has to follow the rules and regulations of SEBI and the company law. So any prospectus which is being issued as a document inviting offers from the public for the subscription or for the purchase of, right, any other document inviting offer from the public for the subscription or for the purchase of any securities of the body corporate, they can use various methods of the prospectus which are provided under the Companies Act. Now, in a brief, let us recapitulate what we have studied or what I have discussed. So I try to explain to you the types of the prospectus by dissecting section 2 clause 70 of the Companies Act 2013, that is about the prospectus meaning. Then we have also discussed one more type of the prospectus, that is abridged prospectus. then advertisement of the prospectus, shell prospectus, then the importance of the shell prospectus, red herring prospectus, then other types of the prospectus like any notice, circular, advertisement. Sometimes we also read in standard textbooks, that is statement in lieu of prospectus. And this is in the form of maybe the notice, maybe in the form of the circulars, the statement also in lieu of prospectus. And one important point is that all the prospectus, all the types of the prospectus as equal liability, all the types of the prospectus will have the equal amount of the liability and the legal obligation in the eyes of law. There may be one of the question you may have. So when we have the same legal obligation, why the various types of the prospectus have come into existence, and who is the beneficiary in advantages? The preparation of the prospectus, a complete prospectus, involves lot of money and also the time. In order to save the money and time, the companies are provided various mechanisms under the Companies Act to prepare the prospectus which are required to them as far as the corporate law is concerned. It is not a complete, what we can say, a company has to follow this prospectus, A, B company should follow this prospectus. Because preparation of the prospectus involves lot of time and lot of capital, a lot of other factors are involved, and there is also requirement once you prepare a prospectus, approaches the public, there is a possibility that you will get a complete subscription of the shares. Sometimes you may not get the share subscription also. Therefore, the corporate law under section 30, section 31, section 32 provided various types of the prospectus as the evolving of the subject and development of the corporate law is evolving, is also changing dimensions from time to time. So with this, I will stop my lecture here. In the next class, we will talk about a broader case laws, a discussion about the liability of the prospectus by taking some of the landmark cases. Thank you all for patiently listening. Kindly put your comments or any of the important points if you want to discuss, and based upon your points and comments, I may prepare a detailed lectures on a specific concept as and when the listeners may require, as and when the listeners made a request depending upon the examinations. This lecture is only on the types of the prospectus, completely based upon the provisions of company law, that is Companies Act 2013. Thank you for listening patiently. We will meet again in another lecture. Thank you once again.